Many years ago, I had a client named Jerry who came in to set up his estate in a way that was independent from his wife, Peggy. This was not because he was trying to leave her out or cut her off. In fact, it was exactly the opposite. Jerry loved Peggy deeply, but he was worried about what would happen to her if he died first. He described her as one of the kindest people he had ever known, which was one of the reasons he loved her. Unfortunately, he also believed that same kindness made her vulnerable to people who would have no hesitation asking her for money until there was nothing left, including the people closest to her. His concern was not theoretical. Jerry believed that some of Peggy's siblings would pressure her for money if she inherited everything outright because they were already pressuring her over the years, but it was Jerry's money and he got to say no. Even more painfully, he believed Peggy's own mother might do the same thing if the opportunity presented itself. Jerry was not worried that Peggy would waste money on herself. He was worried that she would give too much away to other people because she would feel guilty saying no. In his mind, the danger was not that Peggy would be irresponsible, but that she would be generous to the point of eventually being financially unsafe. As we talked through his concerns, I explained that the plan needed to do more than say who received what after death. We also needed to answer the larger questions that drive the entire structure of the estate plan. That meant we needed to begin with the first of the big four questions. Who did Jerry trust to handle financial decisions if he could not handle them himself? That was when Jerry started trying to slide away from the question. He wanted to talk about protecting Peggy. He wanted to talk about who should not get control. He wanted to talk about what he did not want happening after his death. All of those concerns mattered, but they did not answer the question. I still needed to know who he actually trusted to step into a financial role if someone had to act. Jerry kept circling back to the idea that the document should say what he wanted, and if the wishes themselves could somehow carry out the plan without having any human in charge. Finally, Jerry leaned back and he gave me an analogy that stayed with me for all these years. He said, if Donald Trump says he wants a ham sandwich, he gets a ham sandwich. And this was long before Donald Trump actually became president and at the height of Trump's reality TV career. And Jerry was simply using him as an example of someone wealthy and powerful enough to make things happen. I asked Jerry a very simple question. Who did Donald Trump ask to get him the ham sandwich? Jerry looked at me like the answer was obvious and said, well, it didn't matter. In his view, Donald Trump would get his ham sandwich because that's what people like Donald Trump did. That was when I told Jerry that I don't care how rich or famous Donald Trump was. If he was standing alone in a room and shouted that he wanted a ham sandwich, one was not going to magically appear in his hand. If he told his assistant that he wanted a ham sandwich, then it was the assistant who would actually get him the ham sandwich. That was the point Jerry needed to hear. Estate planning does not work because wishes are written down in impressive legal language. Estate planning works because the documents give real people the legal authority to carry out those wishes when the person making the plan cannot do it personally before or after death. I explained to Jerry that I needed to list 3 people in succession who he trusted to get him the financial equivalent of that ham sandwich. I needed to know who would be first in charge of financial decisions if he could not act. I also needed to know who would serve as the backup, and then who would serve as the emergency backup if the first 2 couldn't do it. That was when Jerry finally stopped trying to avoid the question. He realized he couldn't protect Peggy from the wrong people unless he first identified the right people. He also realized that refusing to choose someone trustworthy did not create protection, it created a vacuum. Once Jerry understood that, the conversation changed. We were no longer talking in circles about greedy friends and relatives, kind-hearted spouses, and vague concerns about future pressure. We were now talking about the actual people who could be trusted to make financial decisions, protect Peggy, and carry out the plan if Jerry was no longer able to do it himself. That is why the big 4 questions matter so much. They force our clients to move from general wishes to specific decisions. They also remind us that a plan is only as strong as the people chosen to carry it out. I believe a lot of attorneys overthink estate planning in general. They make estate planning into something that it does not need to be. They overcomplicate things and create the impression that clients need to become experts in probate law, tax law, trust law, and healthcare law before they can make good decisions. In reality, when you are doing estate planning as the client, there are really only 4 big questions that you need to answer. Once those 4 questions are answered, most of the rest of the work shifts to the attorney to make sure those decisions are properly reflected in those estate planning documents. I usually explain it this way. Let's assume we put everything together exactly the way you want it. The documents are signed, the trust is funded, everything is complete. You leave my office after your signing ceremony and you drive away feeling relieved that finally it's all done. Then bang, you're in a car accident. You don't pass away, but now you're in a coma for 6 months. So with that specific hypothetical situation, the first question becomes very simple. Who do you want stepping in to handle your finances? Who is paying the bills? Who's moving money around if necessary? Who's making sure the mortgage gets paid, the lights stay on, the insurance premiums continue getting paid, and everything else keeps functioning while your family is focused on how you're going to recover? The goal is that if you wake up 6 months later and eventually return home, you are returning to your life rather than returning to repossessions, foreclosures, disconnected utilities, and financial chaos. If you do not make it at all, the same person often ends up making the financial responsibilities involved in administering your affairs. They're making sure that everybody receives everything from your estate that they're supposed to get. Now, for that reason, we're looking for one person. If they cannot do it, we have a backup. And if they cannot do it, we have a third just-in-case person. One person, one backup, one emergency backup tends to work remarkably well. Now for the second question. It's that same exact car accident and the same exact 6 months coma scenario, but now we're no longer talking about finances. We're talking about healthcare decisions. Who do you want handling those decisions for you? Who is talking with the doctors? Who's deciding on courses of treatment? Are we doing surgery A or surgery B? And who is signing all the paperwork that seems to appear every few hours when somebody is in the hospital? Somebody has to have the authority to make those decisions, and more importantly, somebody has to be the person you trust to make them. Once again, we're looking for one person. If they can't do it, we have a backup. And if they can't do it, there's that third just-in-case person. Sometimes the financial person and the healthcare person end up being the same person. Sometimes they don't. The question is not who would be fair or who might get their feelings hurt if they're not chosen. The question is who you trust to make those decisions if your family is standing in a hospital hallway and somebody needs to decide what happens next. Now we're going to move on to that third question, and this is the part most people think of as estate planning. If you do not make it out of the hospital in that same scenario, you pass on. Who gets your assets and how do they get them? This is usually the point in the meeting where some of my clients become a little frustrated with me because I start killing off their loved ones in these hypothetical situations to see where the money actually goes. If one child passes away before you, where does their share go? If they had children of their own, do those children step into their parents' place and split what their parent would have received? Most of my clients answer yes to that question almost immediately. And then we usually take it one step further. What if those grandchildren had already passed away as well? Where does the money go then? Most clients immediately say it should simply return to the surviving children. We keep working our way through those scenarios until we reach a point where the family is comfortable that no matter what happens, the assets will eventually end up where they intended. One of the recommendations I make during this process is to rely heavily on percentages whenever possible. Clients often begin by saying they want one child to receive the dining room set, another child to receive the house, another child to receive the car, somebody else to receive a particular account. The problem is that life changes. 5 years from now, half of those assets may not even exist anymore or be possessed by you. The house may have been sold, the car may have been traded in, investments may have changed institutions entirely. If your true goal is simply that your 3 children receive everything equally, then the percentages and fractions solve that problem beautifully. It doesn't matter what assets exist when you pass on at that point, because whatever exists gets divided according to the percentages you've selected. Percentages age much better than inventories. There is one more piece of this question that becomes extremely important if assets are eventually passing to younger beneficiaries in these scenarios. There needs to be an age of inheritance put in place. For that age of inheritance, most of my clients are going to pick the age of 40. Now, when most people hear that, it sounds incredibly old. They hear 40 and immediately think that means the child isn't receiving a penny until they hit middle age. But no. That's not actually how these trusts work in the real world. Between 18 and 40, the trustee has the ability to give money out for certain things, pay for certain things, and take care of whatever needs that they feel are appropriate directly to the child. Before that, it goes to the guardians. Maybe that means paying for college. Maybe that means helping with a down payment on a house. Maybe that means helping start a business or helping through a difficult period in life. The trustee has the flexibility to look at the situation and make decisions that make sense for that particular beneficiary at that particular time. They do not have to simply sit on the money and refuse to distribute anything for 22 years. And understand that it is the trustee that can always accelerate distributions if they believe it's okay to do so. If the beneficiary is 28 years old and looks totally responsible, has a good career, handles money well, and they appear financially mature, the trustee can say, well, there's no reason to hold this money back another 12 years and simply distribute the inheritance outright. They can do that. The trustee is allowed to do it because at the age of 40, it's not intended to be a prison sentence for responsible beneficiaries. It's intended to be protection for beneficiaries who may not yet be ready to handle a large inheritance on their own. The reverse, however, is not true. Once somebody reaches 40, the trustee generally can't decide, well, I still think you're irresponsible, so I don't want to give you the money. At that point, they kind of have to distribute it. Most of my clients universally agree that if someone has not gotten their financial act together by the time they're 40, they're probably not going to. Holding that money back another 10 years is not going to solve the problem, so they might as well receive the inheritance and just move forward from there. That is really how the age of 40 works in practice and why so many of my clients end up being comfortable with it. Now we're going to move on to the fourth big question. Who do you want raising minor children or disabled adults that you are a guardian for? This question is completely detached from the money. This is not about investments, inheritances, trusts, or financial management. This is simply about who would be taking care of those children or disabled adults on a day-to-day basis and who you would trust to step into that role if you can't be there yourself. The money part of that equation is already handled by the first question because the people handling the finances should be able to work together with the people providing that care and oversight as a guardian. Guardianship is about raising children, getting them to school, helping with homework, taking them to doctor's appointments, and handling all of the countless little responsibilities that come with actually taking care of another person. Financial management is a separate issue entirely, and that's why I separate those two decisions in my discussions with the clients. Just like those first two questions, we're looking for one person. If they can't do it, there's a backup. And then if they can't do it, there's a third just in case person. Having that structure in place provides a tremendous amount of clarity if something unexpected happens, and it avoids the confusion of family members trying to figure out what you would have wanted after the fact. That leads to one of the recommendations I make throughout all of estate planning. Don't pick co-anything. No co-executors. That doesn't work well. Co-trustees generally do not work well. Co-powers of attorney generally don't work well. Co-guardians generally do not work well either. Shared authority sounds fair when everybody is sitting around a conference table talking about hypothetical but rosy scenarios, but crises have a way of exposing every weakness in a plan. Even when it comes to guardians, I will have clients tell me they want their brother and sister-in-law to serve together. Most of the time, that's not actually what they mean. What they really mean is they trust their brother, and their sister-in-law simply happens to come along with the package because they're married. The problem is that life changes. People get divorced. Relationships change. Circumstances change. Suddenly, the documents are requiring two people who may not even be speaking to one another to jointly raise children. What clients usually mean is they trust their brother. If that's the case, name the brother. If they truly trust that sister-in-law independently, then name the brother first and the sister-in-law second. That way, if the brother cannot serve for some reason, the sister-in-law steps in and there's still a clear chain of authority without forcing two people to try to share the same role at the same time. That same principle applies almost everywhere else in estate planning as well. One person at a time tends to work much better than trying to create committees. Crises are not the time to be holding votes or trying to get multiple people to agree on every decision before something can happen. In a crisis, clear authority almost always beats shared authority. The beautiful thing about the big four questions is that these are really the main decisions my clients need to make. Once those decisions are made, the rest is largely on me. My job is to take those answers and make sure they are properly reflected in the document so that everything works the way it is supposed to work when it is actually needed. Unfortunately, this is where I think some attorneys start making things much more complicated than they need to be. They start asking, well, who do you want as executor? Who do you want as trustee? Who do you want as power of attorney? Who do you want as conservator? Who do you want as guardian? The reality is that most of those questions are really just subdivisions of the same larger questions we already answered. If the question is who do you trust to handle financial things, then that answer should flow through all of the other financial positions in the plan. If the question is who do you trust to make healthcare decisions for you, then that answer should flow through all of the healthcare and personal care positions in the plan. There is very little reason to ever take what is one decision and artificially split it into 4 or 5 separate decisions unless there's some very specific reason to do so, and no one's been able to come up with something that makes sense to me. To me, separating all of those positions out is a little bit like going to McDonald's, walking up to the register and ordering a chicken sandwich, a large fry, and a Diet Coke, only to be told, well, we can take your order for the sandwich at this register, but you need to go to the next register to order the fries. And then when you get to the next register, they tell you, oh, well, we can take the fry order here, but you need to go to a third register to order the drink. Technically, that system works, but practically it makes absolutely no sense. The same thing is true during a crisis. You do not need 3 different people trying to coordinate financial decisions while nobody is entirely sure has authority to do what. And that's what happens if you have one person as a trustee, another person as a power of attorney, and another person as an executor for after you've passed on. It just doesn't make any sense. All 3 of those people at the front of the line should be the same across all of those documents. And the same thing for the second and the third. You do not need healthcare decisions broken across multiple people. If a guardianship ends up being needed, why should it be different than your healthcare power of attorney? So this is how the big 4 questions work. Those are the main decisions my clients need to make, and once they answer those questions, the rest of the process becomes surprisingly easy. Now, as I always tell my clients, please stay safe, plan ahead, and enjoy life, and whatever you do, make it a great day.